First of all, a big welcome to everyone who has joined and is listening to this webinar. It's actually the first webinar, Baltic webinar that we're doing under the WIDEN name. We've done several in the past, but it's a landmark moment for us as a let's say a single firm. I'm Rauno Ginkar, one of the partners and management board members here in WIDEN Estonia, and I will be the moderator today. So what are we talking about in general? We're talking about how to get from innovation to regulation or from regulation to innovation. More specifically, we're talking about the AI Act that is coming up in the EU, all of the member states, what effects it will have both in terms of data protection, privacy, but also copyright and the tech perspective as well, as later talked about by Martin Karu from Sparkle, who's also on the webinar. Esteemed guest of ours, some ground rules or house rules for this entire webinar. If anybody wants to ask anything, please feel free to turn off your mic and ask the question. I am not sure we would be able to follow your raised hands. So if you find a good opening, just yell out the question or write the questions in the chat, which either one is better for you. And then we will monitor the chat, and when we get the time, and if we get the time, we will answer them. In any case, we will answer all the questions later by email. If you leave your email address in the chat, or we have your email from registration anyway, so either way works. Another ground rule, we will send you the slides later, so no need to take screenshots or anything like that. You will get all of the slides to your email addresses. And if you ask questions, then also answers to your questions. Let's move forward. Let's get this started because we don't have a lot of time, but we have a lot of material to go through. The AI Act is not a small thing. First, what is WIDEN? Why are we even here? Why are we talking to you guys? WIDEN is a Baltic law firm. We have offices in Estonia, Latvia, and Lithuania. Now, well more than 120 people all across the Baltics. We do everything. There is a cheesy phrase, but we're a full service law firm, as they say in the industry. We do everything from M&A to data protection to licensing contracts to criminal law, compliance, environmental, and tax, you name it. And our slogan is the Legal Jazz Company. As you may have noticed, we used to be 3 different firms with 3 different names. In Estonia, we used to be Lextel, Latvia Rare Lextel, and Lithuania ILO Lextel. Now we're all one big happy family under the WIDEN brand. We're the Legal Jazz Company. If you're interested in what that slogan actually represents, feel free to ask about it privately. Happy to explain. There's a very long explanation behind it. We're very happy about it. But in short, it means we're doing things with a passion and with precision. Let's put it that way. And we work well in a team. Moving on. What do we do? So the easiest way to present what we do is just to show a slide of a random assortment of some of our clients that we service across the Baltics. This is it. Probably most of them don't need any grand introduction. They are trusted clients of ours. But today is not about them, it's about you and the information that we can share with you. And what will that information be? First of all, I'll do a very short intro just to get your kind of gray cells moving and thinking about what implications this new technology of artificial intelligence will bring to us. Then Henri Ratnik, who is an attorney at law here in Estonia, will and co-head of the IT/IP team, will do a quick overview of what the AI Act actually is. Then Asta from Lithuania will do an overview of what the implications for copyright will be. And then Anete from Latvia about data protection and the implications of AI on privacy, which are profound, to say the least. And finally, we have a guest speaker, Martin, who will be talking about AI as, let's say, for lack of a better word, as a practitioner, as someone who is actually in the tech and knows about the nitty-gritty of it all. But first, a quick tease into AI. And I will rattle through this very quickly because we really do not have a lot of time, so bear with me. Some time ago, when Midjourney first came out, Midjourney is an artificial intelligence-based generative image generation tool, allows you to make pictures out of prompts. A lady with the surname of Kashtanova in the US published let's say a comic book, for lack of a better word, called Zarya of the Dawn. She applied for and actually got copyright registration in the US. The US copyright system is very different from the most of EU copyright in that you need to register it. She registered the graphic novel in the US and actually got it. All the images there were created by Midjourney. Interesting. Let's think about this a little bit. A work of art that was copyrighted, parts of which were generated by AI. What does that mean? To answer that question, this is a picture, obviously, of Oscar Wilde, taken a long time ago. And the US Supreme Court, there was a dispute, I think it was in the 19th century, about whether or not a local newspaper is allowed to print this picture without the authorization of the author, because the claim by the newspaper was simply that if you take a picture of something that already exists, it's just a physical representation of that object. There's no artistic intent to it. So the Supreme Court started deliberating on the nature of authorship in general. And this actually becomes very relevant in the context of AI, and I'm sure we'll get a lot of questions once Asta finishes her presentation on copyright. But I'm just trying to throw out a couple of questions. And then the Supreme Court simply said that if a photograph is not merely a reproduction on paper of the exact features of some natural object or of some person made by a machine, but representatives of original intellectual conceptions of the author, then it could be considered as a work of art. And they further went on to describe the author as such: he to whom anything owes its origin, originator, maker, one who completes a work of science or literature. And then went on to explain that if it's merely a mechanical process with no place for novelty, invention, or originality, then in such case, the copyright has no protection. Why this is all relevant really is that the same questions arise also with AI, obviously. It's not clear whether there is an author, and it's not clear whether or not it's merely a reproduction made by simply mechanical means. Obviously, the Supreme Court found that a photograph does have an author, but not necessarily will be the case for works of art generated by AI. So this was a landslide or a landmark decision in 1884, Barrow-Giles Lithographic versus Sereny. What about a phone book? If a picture has an author, does a phone book have an author? Well, the Supreme Court of the United States, as recently as 91, said that there can be no copyright in a work in which the creative spark is utterly lacking or so trivial as to be virtually non-existent. Again, we see that quite clearly relevant in the context of today's AI. And I'm referring to the US Supreme Court, not because it's directly applicable in the EU, obviously, but these ideas and the legal philosophy behind it is quite universal. So if a work of art has no creative spark, then not copyrightable. Again, very relevant in the context of AI. And then finally, I think the most interesting case law from the U.S. Supreme Court that is also relevant in this matter is the question of whether or not the Word of God has an author and is copyrightable. The case there was a book, the author of which said, "I am literally writing down the words of God here. These are not my words; these are the words of a God." And then the Supreme Court found that there has to be some element of human creativity in order for the book to be copyrightable. It's not creations of divine beings that copyright laws were intended to protect. Again, extremely interesting in the context of AI, because the same logics that would be applied to something as common and old as Word of God in written form seems to be also relevant in the context of AI. What does all that mean? So what it means in the long run is that the US Copyright Office changed their stance. They explained it in a very lengthy document and finally came to the decision that Zarya of the Dawn will be copyrighted in the written parts and the arrangement of the pictures, but the individual images themselves will be denied copyright. And with that, I will introduce our first speaker, Henri Ratnik. I hope that little side tour got you thinking about the complexities of this matter and why this will be, let's say, interesting, but also complicated from the point of view of the legal scholars. I will give the word to Henri now. I see that he is setting up his screen sharing. Take it away, Henri.
Yes, hello from my side as well. I hope that everyone is seeing the screen now. So let's get into the details with the new AI Act. What and why? So we have a new act from the European Union, which is already actually in force and will start applying very soon. And it's from the EU and it's a regulation. This means that it applies directly in all member states of the EU, including the Baltics. What's interesting about the AI Act is that it's a first in the world, which regulates AI horizontally and in that scope as it does. So it's quite innovative. And when talking about the purposes, what the AI Act is trying to do is that, first of all the purposes are good, obviously. The purpose is to ensure that the AI systems which are used in the European Union, they are safe, so nobody gets killed. They are transparent, so everybody understands what the AI actually does. They're traceable, so logs are kept. And of course, they are non-discriminatory and environmentally friendly. So all good purposes. And another purpose is also to promote the uptake of human-centric and trustworthy AI. So people will actually start using more and more AI in their everyday lives because AI is safe, traceable, and so on. But what is very important to understand is that AI Act does not rule AI in a whole. Still, the existing non-AI specific laws will be still in force. For example, the Copyright Act, which Asta will discuss later, and GDPR, the data privacy, which Anete will discuss later, these are still intact. So, for example, if you build your AI system using content, for example, photos, videos, text, without a license or without a consent, then this will be still infringement of the Copyright Act. and not so much of an infringement of the AI Act. And for example, if you build your AI system infringing the privacy laws, for example, you do not have the consent or other legal basis of processing the personal data, then you are still infringing the GDPR. And this is a larger point, that the AI Act as a whole is trying to prevent the negative impacts that the use of AI has in our society, whereas the existing laws already deal with these kind of negative impacts. So this is an important note regarding the AI Act. Also important is that when a lot of people are talking about the new EU regulations, people are talking that the EU will be less competitive, for example, as regards to the US and so on. But it's also important to understand that the US service providers who will want to act in the EU and will want to serve EU customers also have to apply the EU AI Act. Because they are targeting their services in the EU, so it will be quite a big thing. To continue, why should you pay attention? Very important slide. And as you may guess, the answer is in that picture. It shows euros, dollars, yenis, as said by Tom Cash. So why should you pay attention? First of all, you are a good and law-abiding citizen. You want to follow the rules, you want to follow the laws. But secondly, AI Act will have big fines like the GDPR has, even bigger actually. AI Act says that if you infringe AI Acts, then you will get a fine up to 35 million euros or 7% of the annual turnover. So like with the GDPR, we will most likely see huge companies getting fines in millions and millions, or even close to $1 billion because they are infringing the act. And third of all, also important fact, or also important argument is that applying the AI Act will become a standard part of any legal due diligence. So for example, let's say that you are building an AI system with your startup at the moment or with your company. You are going to say that I'm going to ignore the EU AI Act. I don't care. So let's move on. Let's just build our products and make it as good as we can. And you want to sell your product, you want to sell your company in 5 years. Then the potential investor, the potential buyer will look into the fact whether your company followed the AI Act. So following the AI Act will become a standard part of the legal due diligence. If you do not follow it, then the company does not get the money or less money. But let's get into more detail then. So we have the AI Act. How to tackle it? 3 very easy or not so easy steps. First of all, if you are an AI developer, you have to understand whether the AI Act even applies to you. Does it apply to you or doesn't it not? Second of all, if it applies to your company, then you have to understand how does it apply to your company. So what are the rules, what are the obligations that apply to you? And third of all, you have to obey the rules. You have to obey the rules and get external help if you need it. And that's why we are here. And these are the 3 steps. But going into the first question, so how do I know if the AI Act applies to me? For that, as anything, you should know of the EU AI system, because the AI Act applies exclusively to AI systems. And in order for something to be an AI system, it must meet certain requirements of the AI definition, which is provided in the Act. First of all, in order for a system to be an AI system, it must be machine-based. Kind of obvious. It must be run on hardware. Okay, that's clear. Second of all, it must have some kind of varying levels of autonomy. And by that, I mean that an AI system must have some degree of independence and capability to operate without human intervention. So some kind of autonomy as well. The third important point is that it may exhibit adaptiveness. It is not a must, but if an AI system exhibits adaptiveness, then it's definitely an AI system. And the fourth very important point here is that in order for a system to be an AI system, it must have the capability to infer. So it means that it should be able to independently draw conclusions from analyzed data and have some kind of output, give you some kind of recommendations, make some predictions or something like that. So the ability to independently conclude or infer is something that makes or breaks an AI system. This also means the same point also means that a simple program which is automated by the programming language will not be an AI system because it doesn't have the capability of inferring. And also important is that the AI system can be a standalone product or a component of a product. For example, it can be a component of a Tesla car, which has the capability of self-driving. So if the system meets all of these requirements, then we have an AI system. And when we have an AI system, then the new act applies. Examples, a lot of them. Lots of things can be AI systems based on this definition. For example, we have if you have a medical device which has the capability of giving a diagnosis to a patient, this can be an AI system based on this definition. A creditworthiness assessment software tool can be an AI system. Lots of different examples may fall into under this definition. And okay, so we are at this stage where we know, for example, that we have a company which is building an AI system. Okay, that's clear. So what kind of obligations do I have? And in that sense, the new AI Act talks about risk-based approach. So what the AI Act does is that it puts AI systems in different categories. And depending on the category, it states what kind of obligations does the system have. So first of all, we have unacceptable risk. So these are systems that are forbidden. There are some examples, not a lot of them. We will get into the detail soon. Next of all, we have high risk systems. So systems which are allowed, but there are many obligations which must be followed. Then we have the limited risk systems, which are not so risky, and then we have the minimal risk systems. So let's go into detail now. First of all, the unacceptable risk. So it's like a forbidden fruit, as can be seen on this picture. Unacceptable risks are the few cases, extreme cases where a system is forbidden by the EU, and there are not a lot of those cases. For example, we have social scoring. So this is the Chinese example. China was building a system by giving its citizens scores based on their behavior. So how good of a citizen are you? Do you recycle your waste? Do you pay your bills on time, and so on? This kind of thing will be forbidden in the EU. That's that, as simple. Then we have, for example, real-time biometric identification. And if there was a lot of disputes regarding that. It applies to public places and by the law enforcement. So, for example, the AI Act says that the police in Estonia cannot have cameras on Vabaduse väljak to monitor with the CCTVs people as regards to their biometric identification. Or, for example, the police in Paris cannot have video cameras next to the Eiffel Tower, which have the biometric identification software on them to recognize terrorists and criminals and this kind of stuff. This kind of stuff will be forbidden. It was a very hard dispute, but as they say, the privacy won in that sense. And then we have lots of other stuff. I will not go into detail with them because we are short in time, but some extreme cases will also be forbidden, and this is important to remember. But these are extreme cases, as I said, and most probably, if you are not building a social scoring system or you're not scraping facial images from the web to build a facial recognition database, then most probably you will not fall under this category. Okay, so this was the unacceptable risk category. Some systems are forbidden. Understood. Then next of all, we have the high risk category, and this will be the most practical or interesting one. So what is a high risk AI system? by definition. There are two categories of high-risk systems according to the AI Act. So first of all, we have AI systems which are intended to be used as a safety component of a product, or the AI system itself is a product and the EU product safety legislation already applies to it. Difficult definition. Let's just talk about the examples. It's much easier. So high-risk system is a system, for example, which is in a car, for example, a Tesla car, or which is in a medical device, which is trying to diagnose the patient, what kind of disease does the patient have, or a system that is used in civil aviation. So these are the fields that the EU product safety legislation already applies. And the AI Act is just like another layer on top of that. And then we have the second category of stuff that falls onto the high risk definition. And this is defined by the industry where the AI system is used. So there will be certain fields or industries where using an AI system will, in most cases, fall under the high risk definition. There are some exceptions, we will not go into them. But for example, and these industries, there's like 30 or 40 of them. I will just go into a few of them. So education, for example, if we have an AI system that is putting grades to students at schools, AI system itself is looking over the math homework. The math homework is put into the AI system and the AI will put a grade to it. Then this is most likely would be high risk AI system. Employment field. If we would have an AI system which is used to understand from 100 job applicants which one is the best and which one should be employed, then most probably this will fall under the high risk definition as well. Critical infrastructure. For example, if we have an AI system that is run on traffic lights, so red, yellow, and green, and this would also be most likely a high risk AI system. And lots of other stuff. For example, creditworthiness assessment, emergency calls, public services, and so on. So there will be, as I said, around 30 or 40 fields where using an AI system usually falls under the high risk category. Okay, so as understood, high risk can be first category or second category, but what are the obligations then? For example, let's say that I have a company. I am building an AI system to put diagnosis to patients, like a medical device. I'm building a software that helps hospitals, doctors to assess what is wrong with the patient. Then to understand the risk, the first question I have to ask is whether I'm a provider of the system and or a deployer of a system, because these are two different things and the obligations that you have depend on it. So you're a provider of an AI system if you develop the system or have it developed and you place it onto the market under your own name or trademark. So if I am building an AI software, which are used by hospitals to diagnose patients, and I am placing it market under my own brand, then I'm a provider of this AI system. And the deployer is a different thing. Deployer is a case where an AI system is used under its own authority. So for example, I have a company for HR stuff. I'm buying in an AI system to make my life easier. I'm using it for my own purposes, so to say. Then I won't be a provider. I may be a deployer in that sense. And going on with the obligations. Okay, we have providers, we have providers, and we have deployers. So the obligations are different, obviously. So the providers are the ones who will have the most obligations from the AI Act. So as I said, I'm trying to produce and put into a market an AI system for hospitals, for example. Then I have the following obligations, and I will very quickly go over them because there are lots. First of all, I have to put into work a risk management system to assess the risks which are inherent to the AI system and also mitigate these risks. I also have to put into place a quality management system to understand whether the data that it's used to develop the AI is actually of quality. I also have to draft a lot of technical documentation. I have to explain how the requirements are met. I have to keep logs of the AI system. I have to provide transparency and instructions to the users, so the users actually understand how to use my AI system and how does it work. I also have to guarantee a human oversight to the system. And as a high-risk AI system provider, I also have to do conformity assessment. This means that I have to myself assess whether I meet the requirements of the AI Act. And also, I have to register it in the EU database. And of course, post-market monitoring and reporting of serious incidents. So a lot of stuff, so to say. Deployers have fewer obligations. You have to follow the instructions of use. You have to use quality of data when using the AI system, and you also have to ensure the human oversight. And if you use AI to take decisions regarding people, then you have to inform them about it. For example, I'm a bank, I'm using a creditworthiness program to decide whether I'm going to give a loan to a person or not. If I use an AI, I have to provide an explanation to the borrower that, hey, I'm using an AI to decide whether I'm going to give you a loan and at what conditions. So these are the obligations, and as we are very short in time, I will go to the next slide. So the next categories are limited risk and minimal risk. This is the fun stuff, the easy stuff. So as you can already see, we're talking about, for example, deepfake. So limited risk systems have transparency requirements. Deployers must label their stuff as artificially generated when AI is used to generate, for example, photos, for example, deepfakes. They must have some kind of a label on them. And if chatbots are used, for example, to communicate with people, then these people have to be notified of that fact, and so on. So usually and most generally, these kind of requirements are transparency requirements regarding the limited risk. And for minimal risk systems, there usually will be codes of conduct. So basically no rules at all. But additionally, we also have a bonus category, which was not on the pyramid. And this is the general purpose AI models. So some say that the ChatGPT will fall under this category. Some say it doesn't, it's a dispute. But what is a general purpose AI model? By definition, it's an AI model which may be trained on a large amount of data and which displays a significant generality and is capable of performing a wide range of different tasks. For example, like ChatGPT does, it can do a lot of stuff. And if this general purpose AI model has a systematic risk, then you have some further obligations. So the systematic risk is in order to avoid that the AI takes over the world. So a systematic risk system would be a system which has a lot of computational power, for example. And then you have the obligations regarding the GPAIs. You have to disclose technical documentation, how it works. You have to disclose information, how you obey with copyright. For example, ChatGPT must disclose how does it obey with the copyright laws, which is a huge problem, of course. And if you have the systematic risk system, then you also have to evaluate the risks and notify the EU Commission. Going into my last slide, I already see that Asta wants to present her stuff. I will be quick. So there will be at least one AI regulatory sandbox at national level at each EU member state. And the point of that is to provide more legal certainty. So a few players can play in the sandbox, so to say, and figure out how do they actually obey the new EU AI Act rules. And also there will be EU AI Office, which is an office from the EU, which helps to understand companies, what kind of rules, how should the rules be understood, which derive from the Act. because the obligations can be quite general in that sense, and it will provide more concrete instructions. And last but not least, the AI Act is already in force, but the rules shall apply for the prohibited systems from the 2nd February of next year, the GPAI from 2nd August of next year. For the high-risk systems, it will be 2nd of August of 2027, and all other stuff from 2nd of August of 2020. So it will come soon. And that's it from my side. Thank you.
So thank you, Henri. Very fast and very enlightening. I failed to mention before that on the top of your screens, you will see Q&A button. Feel free to click on it and you can submit your questions there. So far, no questions. So Henri did a superb job of explaining everything with supreme clarity. But the next speaker needs no introduction. Asta Macijauskienė, partner, attorney at law, head of data protection, IP and IT in WIDEN Lithuania. And she will be talking about AI and copyright. Asta, take it away. You are on mute, Asta.
Okay. Thank you, Rauno. Hi, everybody. As Rauno already said that I will introduce the topic of AI and copyright. Actually, Rauno touched this topic at the beginning, talking about Zaria of the Dawn case, which I will discuss further. But now let's begin. Copyright and AI. First, we will talk about whether the result of AI generated by AI is copyrightable. It's the main issue, the main problem which is encountered by businesses in all the world. The second topic will be, is learning from copyrighted material legal? As you know, there are many cases already in all the world. Third topic will be, how can I protect AI-generated results? Actually, I've got the request from one of my clients, photographer. He said me that I put so many hours to do something from my photograph. I do art with the help of ChatGPT, and then you say that nobody and nothing can protect my work, as we will speak about the possibilities to get protection under copyright law. These aren't too many, you know. So clients ask, so how can we be protected? We will talk about that. And the fourth topic will be, what do we serve to our clients when we use ChatGPT or other Gen AI? So firstly, we'll speak about the result of the AI, whether it's copyrightable or not. There are fans of AI copyright and there are opponents. So the main, field of fans of the AI copyright is, and the main point of discussions is that machines create valuable commercial work. So it must be protected by copyright, as copyright originated from the idea, from the opinion that if that authors must be protected in the commercial sense. Nobody can, copy or copyrighted work and get the money that you do not deserve. Yeah. So the main idea of the fans of AI fan is that if you put investments to create some work, even with the help of the Gen AI, you must be protected somehow, and the best measure is copyright. Yeah, that you have the author's rights to your work, even though you have not created by your own hands directly. Yeah. So, but the opponents say that the work is done only by machines, and machines only learn from original works, so they gain without paying any money at this moment. Yeah, maybe it will change in the future, and they use your good to create their own money. Okay, so it's not fair according to the opponents of copyright in AI. Another point of view of the fans of AI copyright is that they say that there is considerable amount of creativity when you make your work with the help of Gen AI. For example, you have to create difficult prompts. You have to teach the AI machine to create some valuable work. So you put some efforts, human efforts, but opponents say that copyright is just a human thing. And I remember my old professor, copyright law professor, told that, you know, if the monkey paints the painting, it's not a copyrightable thing because it's animal. Copyright is all about human beings. So you see pluses and minuses of the same argument. The other argument, the fans of copyright say that no other effective protection measures exist if we do not grant copyrights to the author who uses AI to create work. He's not protected. There are no other measures to defend. But the opponents say that, well, wait a little bit. Yeah, we have confidential information protection, we have know-how protection, design protection, trademark protection. You can use another, you know, measures of the law to protect your rights, but these are not so effective. And the last idea in favor of AI copyright is that it encourages, if we will grant the protection to those works which are created with the Gen AI, we will encourage investments. But actually, the opponents of AI copyright also say that we encourage investments when we protect copyrightable works of the authors. So, you know, it's we look from different sides, and these discussions are very hot topic nowadays. We will talk about the different legal systems, England, US, and we will see that there is some general line, but in every state, in every country, it differs. For example, China already has some cases when it was considered that the result of generated by AI might be treated as copyrightable thing if you put some serious efforts forming prompts. If you put your intellectual, you know, efforts while making prompts, you get the result. You can be protected by copyright in China. We will jump to UK legal framework, and UK has some clauses in their copyright law which in some point allow use copyright in works created by machines. It says that the author shall be taken to be a person by whom the arrangements necessary for the creation of the work are undertaken. So it's very similar to China's model, but it has its own peculiarities. And the authors and different lawyers argue, is it really implementable in practice? Because the author must create the work, and the work must be original according to the law. So what is original when we're talking about machines? So lawyers disagree. What will be treated original, because there's no plenty case law, because originally the word original is linked to the individuality of the author, of its expression, of its unique expression. So what is original when we're speaking about machines? It's not clear, and the law does not talk about it. So it's a problem. So we see that UK's legal scheme at some point allows being author and using machine in creation of your work, but from the other point, it's very not clear what are requirements to consider that thing as copyrightable. When we talk about USA, I wanted to discuss here the Rio of the Dawn case, when firstly the officials registered the copyright in that work, but lately they annulled their own, revised their own decision and annulled, and left copyright only to the text and some other points of that book. But they refused to grant copyright to the images generated by AI. So what was the what was the decision based on? It was said that it was made by machine, and it was not a considerable part of the human being efforts. So USA, it's hard to say where they will go, because motivation of that case is very it likes to, I think it tends to go to the side of UK more than to European, Lithuanian, Germany, for example, because in Lithuania, Germany, we have a tendency that such works created by machines will not be copyrightable, because Lithuanian copyright law is based also on the same as German, and they say that only human can make creations which will be copyrightable. And I don't believe that we will have some change in our legal framework at least in the nearest future. Talking about the partial work, so all the tendency is of all the countries, as I've noticed, is going to that direction, that it might be considered that partial, that if we have the work generated by AI and then some amount of work is created by the human itself, and if we can separate these parts, so we can talk about the partial copyright in that part that was made by a human and added to the AI result. So we have to bear it in mind. As you see the picture in my slide, the pie, and if we can cut the piece of pie and we can identify it as a separate part, copyright, it is believable that it is possible that we will have the rights to copyright in this case, but only if we can identify it as a clear part, as a human work. The next topic is learning from copyrighted material legal. So these are, this case is solved differently in different countries. For example, We have USA fair use doctrine, which in general allows learning from material, but it depends on certain cases, because one of the elements deciding whether the use is fair or not is the potential impact on the market of the work which is generated with the help of another original work. There are many cases when authors sued AI machines, machine operators, claiming that they have to pay the money for authors if they use the same type of their creations. For example, if I paint a painting and some guy sitting in China tells the machine, please create the painting in the same type as this author created some time ago, and I received this painting, I printed it, and I put it on the wall. So what does it mean? It means that this guy from China didn't pay the money, didn't buy the original or a production of the painting, and didn't pay the money to original author. Instead, he satisfied him with a similar type of object on the wall. And what does it mean? It means that there is impact on the market, on the actual market, and the author does not receive some money. So it does not fall in fair use doctrine under US, but it should be, decided in every and each individual case according US legislation. What we see in German and Lithuanian model, the rule explaining whether we can base on whether we can learn from copyrighted material is based on directive, which states that you can use for data and text mining purposes some creations, and in Lithuania without paying any money and without getting the prior consent. So you can learn, but there's only exception that the author has a right to indicate in a machine readable way that I reserve all those rights to me. Then machines cannot learn. If it is indicated in machine learnable way, so these AI tools cannot learn from these works. So you can see in the slide the case, the recent case of German model. We still not have anything in Lithuania, but I think in nearest future we will have it. How can I protect AI-generated results? So at the moment, at least in Lithuania, you can, based on design rules, trademark rules, commercial secret protection, and confidential information clauses in your contracts. There aren't any other way. Maybe we can use some other laws like unfair competition, but nothing very actual and very strong at the moment. What do we serve to our clients? You can see here grapes, cheese, and it's very important because if the client asks you to, for example, if you are IT company and the client asks you to make some software, to create some software, and it's a very huge difference if you create it by yourself from the scratch, or you make a prompt in the AI, in some AI tool, and the AI tool generates it maybe from another things that you learned, and maybe it's a copy of some other software code. So it makes a difference because the client pays actually and usually for the original work, and maybe he or she will, or it will give licenses for their clients, ensuring that this IT company has all the ownership, all the copyright ownership, all the warranties that it has ownership. Or maybe some investors will want in the future to invest in that company, and they will make a due diligence, and it will occur that the company does not have ownership because it was the main product of the company, the software was generated by AI. So we have to be transparent to our clients. I don't say that we cannot use because it's prohibited by copyright, no. But you have to be transparent, and you have to be fair in establishing the price if you use Gen AI in provision of your services. Also, you have considered security issues, because there are many hallucinations, many security problems if the code is generated by AI, because bad people may want to use Gen AI for bad reasons. So you have to consider that. And you have to consider also AI tools when you provide services to your clients, because a lot of AI tools prohibit commercial use of their results. At least you have some paid model if you have premium account or something. So please read also T&Cs of AI tools that you use, especially when you make images with the help of Gen AI. So concluding, we have no certainty on copyright at that moment, only basic regulations, and I think that at least in Europe we will go in that way, that the result of Gen AI will not be protected by copyright, but machines can learn from other works, other authors' works, if they do not, they did not informed that they reserve that right to themselves. That's it.
Thank you, Asta. I'm going to take two things away from Asta's presentation. One, that when it comes to AI and IP, it's more or less unclear what is exactly going to happen. That is one. And second, of course, that grapes and cheese are important. And I think that is a message that we can all get behind. But now, introducing our next speaker, it's Anete Bože, an associate from Latvia, who also needs no introduction, experienced lawyer, talking to us about AI and its impact on privacy and the GDPR, obviously. So please take it away, Anete.
Thank you. So I'm Anete Bože from Latvia. I will cover the questions about the Data Protection and AI Act. And I think the big question about it is, will the AI Act set us free from GDPR? And the short answer is no, nothing like that, as the AI Act directly says that it does not seek to affect the application of existing EU law. Moreover, it directly says that it does not affect the obligations of providers and deployers of AI systems in their role as a data controllers and processors. So these are the definitions from the GDPR. As we know, there are two main players, controllers and processors. So if you thought that it will help you somehow to get rid of the GDPR requirements, no. But I will answer also the question, why not? I will remind you that GDPR use such term as technological neutrality. So what it is, technological neutrality? So one of the definitions is that it is freedom of individuals and organizations to choose the most appropriate technology adequate to their needs and requirements for the development. So the GDPR meant to use this technological neutrality to allow to develop new technologies. So therefore, when the AI Act came into the force, the GDPR doesn't need any amendments because it was made with the purpose opened for different technologies, including AI. I will remind you also that the GDPR is not the only EU law that allows this technological neutrality. Also, PSD2, the Payment Service Directive, also is meant to have this technological neutrality. But what it means? It actually means double trouble. So if you can be both, also the requirements will be both, and potentially also you can acquire both of the fines. As lawyers, we use this principle already from the ancient times, from the Romans and the Greeks, ne bis in idem, which in English would be translated not twice for the same thing. So it might seem that you are doing the breach of AA Act. You will not get fined from GDPR, but it is not so because already in different case, this case is related to the competition, but the EU court already said that if there are clear and precise rules making possible to predict which acts or omissions are liable for the subject to duplication of proceeding and penalties, and also to predict that there will be coordination between two competent authorities, the two sets of proceedings have been conducted in sufficiently coordinated manner with approximate time frame, and that overall penalties imposed correspondent to the seriousness of the offenses committed. So it means it's quite possible if you will do the breach related to AI, and it will include also the personal data, you will pay both of the fines. And as we all know, the fines are huge. So therefore, the next question which I would suggest to start to understand who am I? This is actually a funny question in Latvia because one of our presidents asked this question to himself, and you know the president is not the person who you expect to ask this question about himself. But when you will understand who you are under the AI Act and GDPR Act, you will also understand your duties. So I would suggest to make a small play with three actors: deployer, controller, and emotion recognition system. And the name of the play will be Who Am I? So this is our scene. So please turn off your mobile phones because our play will start now. So there is a company, Only Smiling People, limited liability company, which hires only smiling people. They are super proud that they can provide the best service to their clients, and they provide their services with big, honest smile. As the company Only Smiling People have very valuable employees, they already have surveillance system to see whether somebody is not upsetting their smiling employees. The company always looks for the latest technologies to make the smiles even larger. However, the company always also follows the latest technologies, and they know that there is such an AI Act, which from their perspective allows to use AI also for their unlimited services. So they decide to use this surveillance system to add emotion recognition system, as they already have surveillance system to see whether everyone in the company is genuinely smiling. So it means the company already had requirements related to the GDPR. So they decided to add this AI system to provide better service. So it means under the company falls under both of the regulations. So it is both. They are the data processors under the GDPR and deployer or provider under AI Act. The AI Act also requires, quite similar to the GDPR, that the people shall know that there's used AI system. So if you have any questions about this surveillance system, so feel free to get further information from Rauno. But in this scene, we can see that actually AI Act prohibits to use the AI systems to infer emotions of natural persons in the areas of the workplace. So it means even though from the first glance it might seem that you can use this technology, the AI Act mentions many cases when it's not allowed. So in all good place, there should be some thoughts that we should take from it. It means that you always need to actually understand if the system that you are planning to use, and which will include the AI, is allowed by the law. Even though you might have already the documents related to GDPR, it doesn't mean that it will be the same for our AI Act. So it means you might need also to change the GDPR documents that you already have for the purpose if you are aiming to use also AI. So, and the final lesson from this story that we can remind Grumpy in the job. But as my lawyer, I want to talk also about the papers. There are 3 important documents that are related to AI Act and GDPR. So let's start with the conformity assessment, which is assessment of the quality management system and assessment of the technical documentation. In the conformity assessment procedure, the AI Act Annex 7 indicates the information that must be included. So in this part, it is also for you important also maybe not to ask only help from the lawyers, but also from somebody who understands the technical part. Therefore, we also have Martin who will speak maybe about these aspects more. But let's go to the next 2 documents, and these are the fundamental right impact assessment and data protection impact assessment. So the GDPR actually is not mentioning the AI. It is because, as I told before, the GDPR aims to be technologically neutral. So that is the purpose why they are not using specific technologies. They are saying that the data protection impact assessment is needed where the new technologies are used. So we can, of course, say that maybe about AI, there were some discussions in ancient Greek and Roman times, but to be honest, is from the law perspective, most probably it will be new technology. Therefore, if you are using the personal data and AI together, most probably you will need this data protection impact assessment. And when we put these two documents together from the first glance, it might seem that they are very similar. But it does not mean that if you have already GDPR, data protection impact assessment, it doesn't mean that it will automatically cover also the fundamental right impact assessment under the AI Act. They are still two different documents, two different regulations. They are somehow related, but it is not the same. It's like apples and pears. Yes, they are both fruits, but they are different, similar but different. So even if you think that you can be already covered by the existing GDPR documents, then it's wrong. You will need make amendments if you are planning to use the AI. Thank you. That's all from me.
Thank you. So looking back at the presentation, I guess two main things to take away from here. First, GDPR is still alive and well. Need to go through the documents and also processing activities, make some changes, draft some additional documents. If you need help, let us know. And secondly, a good idea to smile at work, just to be safe. But next, we have Martin Karu, digitalization and smart manufacturing expert, as read from his Wikipedia introduction. But I will allow Martin to describe himself in a bit more detail. Martin will be talking about the tech perspective of all of this as someone who is living this from an entrepreneur side. Martin, the floor is yours.
Thanks, Rauno. Good morning, everyone. So I'm a tech person. As shown on this page, I'm representing Sparkle, a data solution company, and I do have background in developing software as a service, as a product, also smart manufacturing solutions, and even 3D cameras. Here's my link. Today, I will cover a couple of different topics. So creating AI solutions, what's the difference between AI, machine learning, and actually code? I will go over the provider and deployer definitions, but I'll use more use cases. And then, of course, obligations and compliance. And then this is another regulation. So is European Union binding their hands and legs, or can we actually create value from this? And are the obligations something odd and irrelevant, or actually useful? So firstly, let's define it. And thank you, Henri, for explanations. I will cover quite a lot of Henri's topics, but I will go into the technical details and just show examples. So everyone's favorite topic, what is coding? You get code if you write code. I, as a person, created this code. Then I deploy the code and give it some value. If this, then the code assesses it and it gives out the output. And this is always the same. The code does not change. With machine learning, and let's call AI here as well already, we actually first choose the model. Then we gather the data for this use case. Credit limits, smiley faces. So the X's here are pictures of people, and the Y is on this picture, is the person smiling or not? And when you train, you get weights. And this means how each of the parameters of X, I don't know, the pixel in the top left corner, how does this affect the smiliness? And then you take the model and the weights, you combine them, and this is the inference part, where you now give a new image or a new person here, and you get the response. Are they smiling or not? And I purposefully define this as a black box. It is exactly a black box, because with code, you always know for this X, the output is this. But with models, there's a bit of autonomy. And let's go to everyone's favorite example, how much can I gamble? You sign up to an online casino. You then define your parameters. You say that I'm a man and I'm above 30. So the casino then gives me some amount of money or a credit limit that I can play. I can put in 100 euros of my own money. And if I would have to do this with software, this is the same tree here, then this is something what it would look like. And everyone loves coding, I know, but it's quite simple. I want to get the credit limit for my gender and my age. And that's my gender level and that's my age. Let's put in examples. If I'm a man and 25, which I'm not, but here we go. Then yes, man equals man. We get to this block here. The age, is it above 30? No, 25 is not. So we get to this point here. And again, for every time you run this, you will get to this exact part here. And that's 50 euros for credit limit. It's deterministic. If we use classical machine learning here, then number one, we gather the data. Let's say we've already chosen the model, and that's going to be a decision tree, which it anyway was. We gather some data like my income level, my employment status, how often do I play and deposit, and how did I pay? And then I train the model and I deploy it, and then I make automatic decisions. And the example, let's visualize it. There's a table, that's the data that I've gathered. Name, gender, email, age, education, and all of these other aspects. And then this is the Y column. How much can I gamble? And if you use, or the reason to use machine learning anyway is when there's too much variance. There aren't just 4 options of how much can I gamble, but there's, let's say, almost infinite amount from 0 euros to 1,000, maybe 5,000 euros. And I would like to be even more granular with it. So that's when you use machine learning. You take the data, you train the model, and you deploy it. And it's a black box. We don't know which of the features it chose to make this decision. You can look into this, especially with classical machine learning, but you cannot with the larger language models and all of those things. The explainability is really low. If we replace this with AI, and let's call it just LLMs or large language models or complicated models here, and we can take complex data, like assess if I'm addicted to gambling, or analyze the time of play, or even analyze how I've interacted with customer support. Am I being obnoxious with them? But then you still train it and you deploy it and you have automatic decisions. And this is the block from a sign up to some value. And the question is, how do you get there? Of course, there is a combination. I can have the machine learning part where I take a person's information, I apply a machine learning model onto it, and then I respond with an assessment. And then there's a tree. The tree is still the same. I signed up, I'm a man, which is this sort of coding part, but at some point we use machine learning models. So here we get to the statement of what is an AI system. If your decision tree, your decision-making process is only code, and it can be an automatic decision from my sign up, what's the amount of money that I can gamble with, then it's not an AI system. It's code, heuristical. I can always go in and see how the decision was made. If at any point I use machine learning, but at the end of it, there's a manual confirmation or manual decision by the person, then it's still not an AI system. It's rather a machine learning based recommender. Hey, this person, man, they should receive 100 euros of credit, and some person clicks yes, let's go. So if there is machine learning, or let's call it AI as well, and there's an automatic decision, then it's an AI system. And the automatic decision, automation, some level or degree of autonomy, that's what defines AI systems. And it can be a combination of code plus machine learning, but if there is machine learning, if there is a black box and there's an automatic decision, then we're talking about AI systems. Recap. If you've seen this on your car's dashboard, if it recommends that, hey, I saw the speed sign and it says 120 kilometers per hour, but it doesn't act on behalf of you, then it's machine learning. But if it slams on the brakes and pulls you into the regulated speed, then it's AI, if the decision or the acting is also done by the system. Another recap of Henri. We have the main roles of people inside of AI Act. And there was the providers, as in people who build AI, and there are the deployers who use the AI system. And in some statements, you can also hear about upstream. That's upstream responsibilities or obligations, and downstream. And it's like a river. Here you create it and here you use it. And the gray people in between are not that relevant in the day-to-day, but rather if you in Estonia, Latvia, or Lithuania are using ChatGPT, then someone has actually imported it into the EU. It's a US-based company. And the roles are relevant, again, and I'm covering some information what Henri already told, but let's go just through the use cases to make it clearer. An example, use case. Your data team built a decision tree for classical statistical analysis. And if you're using this for automatic decisions, then you are actually a provider. And if you're using it, you're a deployer as well. If you're using off-the-shelf components for facial recognition system or happiness detection, then you haven't built anything and you're pretty much just a deployer. But if you've used a ready-made off-the-shelf recruitment engine, but you train it with your own data and you add your logo, or even this last part, if you add your own logo, then you're the provider and you're using it, so you're the deployer as well. And that gets us to obligations. If you're in this role, then yes, you need to define what data are you using, where does it come from, how do you manage it, is it copyrighted, how much compute are you using. It aligns with other European acts such as ESG or guidelines. What was the model? What are the capabilities? And also how to deploy it? How does that get into your hands and where is it allowed? And this is just the documentation part. And then you can assess different types of AI systems on this. This is old information, middle of last year, but it already shows how do you gauge? Are you compliant? Are you as a provider compliant with the AI Act? And here the largest number is I think this 36 out of 48, and this is still you're not fully compliant, is what it means. And to cover or restate the distinction between use cases and the tools. So if you, let's say that the OpenAI and ChatGPT is now a GPAI, general purpose AI, and they are a provider, then that was the systemic risk assessment. And systemic risk assessment does not have anything to do with use cases, and the risk pyramid here is use case part. Is your use case unacceptable or is it high risk? And I will come back into this example in a second. Now, if you're a deployer, reiterating over these, you need to make sure that you know what you do or what tools and where are you using them. Then you need to assess risk and then make sure that you are in compliance with AI Act and GDPR and all the other guidelines. And then, yeah, registering, and even after you've deployed it, you have to make sure that you're still compliant, that you haven't changed anything. Step number 1, take stock. I'm using these tools and I have these use cases. I know at least one Estonian company that's actually doing this and using the same assessment. Is it an AI system, as I defined before? Then you have the list of use cases, and per use case, you assess this risk level. And for that, you have a couple of different assessment frameworks. One of them is Artificial Intelligence Act EU, where you just click, I'm doing this, I'm not doing this, my data comes from this, I have this. And I think the most comprehensive part, the assessment framework today, is GAIRA, as in General AI Readiness Act assessment. Yeah, readiness assessment. So that's the link, and it gives you this sort of radar overview of how do you position yourself. And now we get to the use case part. The tool, if it's ChatGPT, that's the tool. We as deployers, we don't assess its capabilities. That's the provider's role, responsibility. But then how we use it, if you use it for creating a school essay, then it lands into one part. And if you use it for in-car AI and it needs to act while you're driving, then it's another risk category. Reiterating over these as well. You have the list of use cases, tools, and risks, and per solution, per use case, you have to make sure that you're following documentation and you have human in the loop and you know where your data is coming from. And now the question, the last topic I had in my slides was, is any of the obligations actually useful? And I'm in the camp that yes, it is. And everyone's favorite analysis tool, cohorts, done in Excel. So I have a SaaS product. I have customers joining for trials. People who joined in the first week of this year, second week, etc. And I want to track how many new customers actually came and what was the total revenue. And maybe I want to see when do the trials convert to paying customers. Simple, right? And then we also have campaign information from other parts. Let's color code it, then it's easy. We can see that the most number of new customers arrived here on week 4, and the revenue was this. Cool. This is the information that I've seen used by operation managers, by reporting team, by decision makers, pretty much everywhere. How many new customers? But then the question is, who is a customer? And that's the data governance part. Do we have a mutual understanding of who is a customer? And typically, marketing and sales say that a customer is anyone who comes to our site. Finance says that the customer is anyone who gets an invoice. And product team says that the customer is anyone who uses our tool. And the point I'm driving here is that if your company doesn't have a shared understanding of who is a customer, then if you're building or applying any automated tools on top of it, the tool doesn't understand that either. And you cannot apply automated tools on top of information that you don't understand. But this isn't the only question. The questions are also, when does a person become a customer? When is revenue created? Which systems do these numbers come from? Do I copy paste them? Do I have Excel sheets of that? Is the campaign data shown here? Is it automatically linked, or do I have to create the manual stuff, manual integrations for it? If I have to do it manually, then no AI for you, sir. Good then analysis of the seasonality, breakdown of categories, more data. Then a question, who owns the data? Who owns the customer data? Who owns the revenue data? Who has access to the data? Who controls it? Do you trust it? What's the quality? And again, if it's bad quality, then don't build AI tools on top of it. How long do you keep it? How much data do we have? How much does it cost? And what's the ROI? So we would like to build AI solutions, all of us. We would like to be compliant in them. But under the AI solution umbrella, There's the goal. Why are we doing this? There are solutions, there's compliance, and then there's trainings, making sure that people actually use them correctly in the logical sense. So that's the gain part, which refers us to the pain. You need to make sure that you're using proper tools and the processes. You need to make sure that you know what data do you have, the governance part. And the govern here is the person governing it, owning, and quality. And then you need to have the infrastructure in place. And everything needs to fit into the business. So AI systems, they aren't standalone. They need to exist in your ecosystem, and they need to be high quality to make value from it. And final, second to last recap is what is an AI solution? So if you're training your models, or if you have black boxes in your systems, then you have AI solutions, and then you need to firstly keep track of the data that you use for training. Step number one. You need to version your models and weights, and you need to log user interactions. To me, these are the most logical things any proper AI company can do. And now that the AI Act came out and stated that you need to do these things, it's okay. The obligations aren't new. The value isn't new. You should have done this, or you should do this anyway. And yeah, this is what the flow sort of looks like. You take stock. I'm using these tools and these use cases. I assess risk per use case. I ensure compliance per use case. I register it and I monitor it. Thanks.
Thank you, Martin. So, to recap what was just discussed, I think the most interesting revelation from the last presentation was that it even more than with GDPR and with other similar regulations, it's important for businesses to understand what technology they're using, to actually understand how the technology works, and also understand the way it is used. And largely, the technology used and the way it is used will define your obligations. The difficulty there, of course, is it's very, very complicated to actually understand how the technology works. If I'm using a generative AI model, I don't understand how I, as a lawyer, as a typical lawyer, I'm supposed to understand how that technology actually works in terms of GDPR, in terms of copyright, and in terms of general compliance to the AI Act. That will take some doing and probably will take some help. But me as an IT lawyer, and I'm sure Asta and Anete and Henri all agree, and Martin also, that this is an extremely interesting challenge. Law is becoming more and more intertwined with technology, and in order to provide good legal advice, you do have to understand the technology, and this is what we do. So to sum this up, first, thank you to all of the speakers. I think and I hope that it has been useful for everyone. Feel free to add us in on LinkedIn and on Facebook and all other social media platforms you prefer. Also, a quick reminder that we will send you the slides via email. Also, there are some unanswered questions in the Q&A, some for Martin also. We will get back to you with the answers to those as well in due time. And if you have any additional questions, feel free to reach out to any one of us, really. Ask the questions and we will do our best to answer them. That is it from Tallinn, Riga, and Vilnius. Thank you all for joining and have a good work day. Bye-bye.
Bye.
Thanks. Bye.
Thank you. Bye.